Hello and welcome to Introduction to U.S. Law again. And today I'm going to be talking about professional responsibility for lawyers and a little bit about the practice of law. It's James McGrath. You may remember me earlier from our Torts Week. So Chapter 10, Professional Responsibility. I'm going to go over some of the highlights that I think are really important. Of course, the whole idea here is not to talk about lawyers' ethics in a way that helps you to practice law, because only lawyers should be doing that. However, it will help you, I think, with your relationship with your legal counsel and to understand perhaps when you do need to get a lawyer. So, delivery of legal systems. So we have a lot of rules regarding independence of lawyers. We don't want lawyers to be taking orders from people who don't have the client's best interest at heart. So in this country, we don't allow corporations to have a law service for customers. Like Walmart can't set up a legal clinic and man it with lawyers to help people get a legal help. I guess at a discount. That's Walmart's big thing. Now, other countries have started doing this. I think the British version of like Costco has begun offering legal services at their store, but our rules do not permit that. Now, at my school, our law school, I'm sorry, we do have a couple of legal ethics scholars who actually think it might be a good idea in terms of access to legal services, but I'm not so sure, and the authors of your text are pretty convinced it might be a bad idea. There's also rules regarding competence, and I would hope every profession has some sort of rule regarding competence. Lawyers shouldn't be taking any case that they're not competent to handle. The law is so varied, and while you go to law school, you have to study a really broad range of subjects, but most people don't practice in a huge range of types of law. Even general practitioners usually have a limited, a few limited areas of expertise. Now, the good thing about getting competent, lawyers can do one of two things. They can go ahead and associate with another lawyer who is already an expert or competent in that field, or a lawyer can, with diligent study, whether it's on their own in a library or taking a continuing legal education course, they can become competent. So there's something called the unauthorized practice of law. And I've mentioned this already a couple of times, that the point of this course is not to teach you how to practice law, right? You do a lot of things that perhaps are legal-like. Like I know a lot of you write contracts. And of course, you don't have to be a lawyer to do that. However, if you're negotiating with the other party and telling them the effect of the law on this contract, you may be practicing law, right? You want to make sure that you're not doing that. Unauthorized practice of law, it's sometimes, tricky. And when I teach a professional responsibility class for law students, I let them know that every state has a different definition of what is the practice of law. But there are a few things that are definitely the practice of law that you should avoid. One is going into court and representing someone else. If you're doing that, you're probably practicing law, right? Now, you can go in to court and represent yourself, but if you're representing another party, then you're practicing law. There's one small exception in small claims court in many states where a manager can represent their company in a small claims court, kind of as if it was their own business. But otherwise, appearing in court for somebody else, because remember, that person is a manager, that's not them, it's not their company, is probably going to be practicing law if you're representing somebody or something in court. That's definitely. If you write a will for someone, you're practicing law. Now, if you go to Office Depot and you get a standardized will form with some fill in the blanks, that's not going to be considered practicing law. Oh, thank goodness, it was getting kind of hot in here. I don't know if you heard the jet engine turn on. It's just the furnace here. But if you just get one of those forms and are just filling in the blanks, let's say you want to help your mom write a will, and you ask her, what's your name? And you really should know your mother's name, by the way. And then just fill in the blanks as you go along, then you're not practicing law. However, if you get down to a certain point, you say, hey, Mom, I was just noticing all this stuff right here. You know what you really need? You need a certain type of trust. I think it's called a crummy trust. And these are going to help you protect. Now you're practicing law. So that would be, something you don't want to do. Lawyers have this duty not to help people practice law. That's why I keep saying it, right? It's okay to teach someone about the law. I can teach people how to be paralegals, but what I don't want to do is help someone to practice law who is not admitted to the bar. All right. Even lawyers who are admitted to the bar can engage in unauthorized practice of the law. So I'm admitted in Connecticut and New York. I cannot practice freely in Texas without doing something special. Okay. So if you're admitted in one state, you can only appear in court in that one state. Now, here's some exceptions here. One is called the pro hoc vice rule, and that means just for one turn. And so if I want to take a case in Texas, I can associate with a Texas lawyer, and that lawyer has to be involved in the case. It can't just be like, oh, just sign this for me and you'll never hear from me again. They have to show up with you. They're there to make sure that you understand the special rules and the law in Texas. And so you're bringing in that expert who will vouch for you, and the court will admit you to the bar for that one course, right? You'll be permitted to go past that bar. And that's what the bar is, by the way. It's that bar that separates the non-lawyers and the litigants from the rest of the people in the courtroom. You get to pass the bar. And passing the bar exam, so tough, but you really feel like you've earned that place up there. Anyway, I digress again. So pro hoc vice is one way to appear in a state without really being admitted to that jurisdiction. Another way that lawyers can practice a little bit in another state is, let's say you represent a corporation here in Texas, and that corporation needs you to help it negotiate a contract with a firm in California. You can go to California and represent your client. Even in something like arbitration or mediation, that's okay, as long as you're not appearing before a tribunal on behalf of your client. Now, if you are here in, let's say you're admitted to the bar in Texas, and there's a firm in California that wants you to come out and help them do a contract, you can't do that because your client is not from the state where you are. So that would be unauthorized practice of law. There's some areas of the law that you can get a 50-state license for, like I believe admiralty and patent law. You don't have to be admitted in every jurisdiction because it's federal law. I mean, bankruptcy is only federal law as well. But a lot of those cases, well, never mind. I don't want to get too far with that. I'm not going to help you practice law. I know who you are. No, I'm kidding. So competence is just one of the duties that a lawyer owes to the client. They also owe a duty of diligence as well. And by diligence, we mean they have the duty to, pursue matters in a faithful manner that is best not just for your client, but for the system of justice. So you can't just put things off again and again, hoping that a problem will go away. Diligence really means, in this particular, in considering the duties of a lawyer, is to be, have perseverance and to see the matter through.